And Your Honor, I think Mr. Lumpkin, Mr. Rodriguez, well, Mr. Kilgore and Mr. Lumpkin are present.
They are. I think we've got everybody to go forward. Am I wrong? Who are we missing? Can you resume your cross-examination?
Yes, Judge, and I'd like to go ahead and make sure we're rule of sequestration once again.
Okay, Audrey's going to take care of that.
Great.
Mrs. Hastings is going to take care of that. Are they sequestered, Audrey? You think so?
Is it just Mr. Kilgore and Mr. Lumpkin?
Yes, I don't think we have Mr. Rodriguez back yet.
And I'm not sure who TBL client is. Is that Brian Lumpkin client?
No, I don't know. I don't know. Do you have any idea?
I'm not sure. Would you like me to go ahead and put them in the waiting room?
And then when they bang on the door, we'll figure it out.
Yeah. All right. I think we've got everyone sequestered and off. So I will resume. Thank you, Your Honor.
Thank you.
And Dr. Diamond, can you hear me?
Yes, I can.
Great. Were you able to find the email that we were talking about from Maddox Kilgore asking you for your notes, those that were in defense exhibit number 1?
Oh, I was looking for the email in which I sent the notes
Correct.
and I couldn't find it.
Okay. Well, thank you for trying to look for that. So I want to go back a minute and make sure I've covered this. In your initial first meeting with Mr. Harris at the Cobb County Jail on August 10th of 2015, did you record that, like audio or video record that interview in any way?
No, we didn't.
Did you memorialize it in any way, like type it on a laptop or do something else like that?
No,
Okay, and so you didn't do any handwritten notes, no typed up notes, no nothing like that?
no.
Okay. Now, moving forward into April of 2016, at any point in time, did Mr. Rodriguez, Mr. Lumpkin, or Mr. Kilgore, and I'll just refer to them as the defense attorneys, tell you that the state had requested or was demanding any written notes that you had as to what Mr. Harris had said to you during the interview that you had in August of 2015?
Yes, at some point they had requested that I turn over my notes. Yes.
Okay, so about when was that? Was that closer to trial or was that more in the time of April of 2016?
Well, April was when I had that second interview. It was April 30th, so it would not have been before that interview. It would have been after that interview.
So after. So at no point in time did Maddox Kilgore or anyone else tell you prior to the interview on April 30th, 2016, that the state was seeking, because you were the expert and you'd been provided as an expert to the state, your notes about your interview with Mr. Harris and what Mr. Harris said?
That's correct.
And you said Mr. Kilgore went with you April 30th, 2016 to the Cobb County Detention Center,
Correct.
but he did not go with you to the interview when you took your laptop and were across the glass partition from Mr. Harris. Is that right?
That's right.
And the 50-slide PowerPoint, the one that you prepared to testify from at trial, a lot of what was in it included statements that Mr. Harris had made to you. Is that correct?
That's correct.
Right. And a lot of those statements were actually in defendant's exhibit number 1. I mean, you took those notes and then they got translated into your PowerPoint that you were going to testify about, right?
So by exhibit 1, do you mean from the first interview?
The first interview.
Yeah, the one which were all notes on my part. Or are you talking about the second interview, which was typed?
Now I'm confused again. I thought you didn't take any notes whatsoever on the August 10th, 2015 interview.
Well, that's what I'm asking. Are you saying my PowerPoint was based on a specific interview?
No, what I'm actually asking is, are the notes, that is Defense Exhibit 1, which are the typewritten notes, are a lot of what's in your typewritten notes as far as what you typed that Mr. Harris had said, were those statements from Mr. Harris then placed into your PowerPoint to make the point you were going to make at trial?
So they weren't literally the statements from Ross Harris into the PowerPoint, but I used the information in that interview to create the PowerPoint and to include that in the PowerPoint.
I need to interrupt you all for a moment to talk to the clerk on unrelated scheduling matters. So I'm going to do an aside. We're talking 3 seconds. Okay. I'm sorry, I'm juggling several calendars. Is that, well, that's what we do. All right, but that's an explanation of what's going on. I was working with the clerk to make sure everything else was attended to, and it is. So we're in good shape. All right, resume your cross-examination, and thank you all for your patience.
Thank you, Judge. So when we talk about confidentiality, Mr. Durman asked you, did you anticipate that your notes would be confidential? Why would you believe they'd be confidential?
I didn't believe they would be confidential. I asked if they would be confidential.
And who'd you ask?
I asked Maddox Kilgore.
And when did you ask him this?
I asked him before both interviews.
And both times he told you that these notes that you took about the interview with Mr. Harris would be confidential.
Yes.
Did he explain why he believed they would be confidential?
No.
Now, once the 50-slide PowerPoint had been completed, and I'm assuming that was sometime during the trial itself, which started on September 12th, 2016. Do you remember when you completed that PowerPoint?
September 12th. Are we referring to the first scheduled trial or the one that actually took place?
I'm actually referring to the actual trial that took place down in Brunswick, Georgia.
Okay.
Okay. And what I'm referring to is that when I say September 12th, 2016, that's when jury selection started. So that would be when everybody's down there, the attorneys are down there, Mr. Kilgore's down there. Were you, to your best of your recollection, were you still working on the 50-slide PowerPoint that you were about to testify to, or was it already completed at that point?
It was completed prior to that date.
And do you remember when you gave it to Mr. Kilgore?
No, but I believe the date was September 3rd.
And when did you come down to testify in Brunswick?
I was there the same day that the psychologist testified, and I believe I came in I came in the night before.
Okay, so when you say the other person, was that Dr. Jean Brewer?
Right, I was there at the same time as him.
Okay, so does November 3rd, 2016 sound about right for the day you were there to testify?
Yes,
All right, so you kind of came up from Tampa to Brunswick the night before.
correct.
And what did you do the night before? Did you meet with Mr. Kilgore and the team?
Yes, I did.
All right. Did you go over your testimony with them?
Yes,
And the morning of November 3rd, did you go to the courthouse?
yes.
Where did you stay in the courthouse? I mean, did you see Dr. Brewer's testimony or were you somewhere else?
No, I was sequestered in one of the rooms on the side of the courtroom.
Okay. So at approximately, let's see. I think at approximately 11:57, a lunch break was taken. Do you recall meeting with the defense team during the lunch break on November 3rd, 2016?
I don't recall if I had lunch with them.
Okay, so I'm going to get more specific. Forget eating with them. Did you actually meet with them anytime between 12 noon and 1 o'clock when the trial resumed?
I don't recall.
Okay. How were you informed that you were not going to actually be testifying that afternoon?
I think it was at the end of the day that I was told session is over. You're not going to be called. You haven't been called. To the best of my recollection, I wasn't told until the end of the day.
Okay. And when you were told at the end of the day, where were you?
In that same room, I spent the whole day in that room next to the courtroom.
Okay. So to the best of your recollection, Mr. Lumpkin, Mr. Rodriguez, and Mr. Kilgore never met with you at lunchtime on November 3rd, 2016 to talk to you about your anticipated testimony, to talk to you about what Dr. Brewer had testified to, and to let you know whether you were going to be called as a witness or not.
No,
So when you were informed at the end of the day on November 3rd, 2016 that you were not going to testify that day, did they tell you to come back the next day?
no.
What were you told?
I was told that I would not be called to testify.
Okay. And that evening, November 3rd, did you leave and go back to Tampa?
Yes.
Did you ask them why?
I think I did, yeah.
Okay, what'd they tell you?
I remember most vividly, they said that they felt confident about the case because it seemed that everyone in the courtroom seemed to think that he would be acquitted.
Okay, and so they felt pretty good about Dr. Brewer's testimony?
They didn't comment on his testimony.
Okay. Did they feel that they had sufficiently made a case for Mr. Harris and that they were going to prevail?
Objection, Judge. I'm so sorry. I needed to jump in there and couldn't find my mute button. Now they're calling for speculation. I mean, I think you can go in a little bit, and I have let him go in a little bit about the that conversation because it goes to one of the other issues. But as far as what's in their minds, specifically what's in their minds, he doesn't know.
That's probably good. You can rephrase though.
Thank you, Judge. So Dr. Diamond, all I'm really looking for is specifically what the defense team, and it could be any one of them, specifically told you about why they had chosen not to call you to the stand for Mr. Harris.
And what I recall is they, in a sense, surveying people's opinions, it seemed that he would be acquitted.
And you also mentioned they said something about confidence about the case. Do you recall specifically the words they used about that?
No, they didn't say they were confident about the case. I don't know if I just said that. But there was a sense that,
Judge, again, I'm going to object to any sense that he had, anything of that nature.
Well, that would depend on whose sense it is. My understanding is the witness is saying it was the sense of the defense team. If that's the case, and it clearly on objection might be due for clarification. But if that's what he's saying, he can testify. If he's speaking about his sense of what they're saying, it is speculative, Mr. Durham, and you're correct. So, Ms. Dunkowski, I think you need to clarify that.
Yes, Judge, I will. So, Dr. Diamond, what I'm looking for is specifically what they were telling you. So it's not necessarily your sense of what you thought they were trying to communicate. I'm really looking for, did they say?
I think she's been asked and asked, and now we're going to, I think she was allowed to give a reason, but now we're going into some complete hearsay that it would not be relevant any longer. That it has been asked and answered.
I don't think it's.
Have them on cross. So asked and answered, overruled.
How about hearsay?
Well, I'm working on it. If you give me a minute, Mr. Durham, I did pay attention. That's my back at you if my face weren't all covered up. What do you say about the hearsay objection, Ms. Dunkowski?
I agree. It would be hearsay. The problem, of course, is that I'm then going to want to ask Dr. Diamond to hang around in the waiting room until the other three attorneys testify, because they are up on deck, so to speak, and in the waiting room and about to testify. So I would ask for a little leeway at this point in time, just for the convenience of the witness, so he doesn't have to spend another 4 hours sitting in his office waiting to be recalled for me to ask him this one question.
I'm going to allow it over objection only in the way that you've described. And if it's not set up properly, it will be hearsay and it will be overruled. Otherwise, depending on how the other witness's testimony is developed, I'll take argument and decide its admissibility.
Thank you, Judge. So, Dr. Diamond, once again, when I'm only looking for what they were saying to you, their sense of the trial was, what did they say to you?
their sense of the trial, not their personal opinion, but what they had heard from people in the courtroom was,
Again, I'm going to object to what they heard from people in the courtroom.
and that's what they shared with me, what they had heard in the courtroom.
I'm going to make the same ruling and allow it in, and then we'll see how it develops an argument.
Thank you, Judge. As obviously I'm not offering it for the truth of the matter asserted therein. So,
Yes, that's what I'm going to hear the argument on later on.
great. All right. So after you had this conversation with the defense team, you then left and went back to Tampa. Is that fair enough?
That's correct.
If I may have one moment, Your Honor, just to make sure I've covered everything. I will pass the witness, Your Honor.
Mr. Durham, redirect.
Dr. Dunn, just a couple of quick things if I can, please. Now, you mentioned that you plan to testify to certain things on cross. Specifically, they were talking about you were going to testify as to distraction, as to changing plan, as to sleep deprivation, and as to cue. Do you recall that?
Yeah, that's all correct.
All right. Were you not also planning and testifying along with that PowerPoint and the examples that were provided in the PowerPoint and some of the examples that you gave today?
That's correct.
Yeah, so it wasn't limited to just the things that they listed there for your testimony trial.
Correct.
You were also going to testify and use your expertise in the 15 years that you've been in the field specializing in children being forgotten in cars. You were going to testify as your expertise and tie those cases in to be how they were consistent with the factors found in Ross Harris's case. Is that right?
Yes, I would have related The incident in Ross Harris's case, 2 other cases in which I served as an expert.
And then also, you were using your history as far as a brain memory expert, which you've been in that for 40 years, studying the brain and how it operates in brain memory. And you're going to use that experience to tie the factors that you found into Ross Harris's specific case.
Yes, I would have.
In other cases you've worked on.
Yes.
Now, you mentioned they talked to you a little bit about some newspaper articles that you testified to on direct. Now, when you're using, is it common for somebody with your in your field of expertise to read newspaper articles, take news reports, and research? Is that part of the things that you do to base your opinions?
Are you asking me if I use media articles to base my opinions? Was that the question?
Specifically what I'm asking, hang on, specifically what I'm asking is that if you reading newspaper articles or researching and reviewing newspaper articles or reports, is that something that experts in your field commonly rely on when making their opinions?
Well, I consider it a source of information. It's not the final determinant of how I come to my opinions, but I think all information is potentially valuable.
And but again, my question though is, do other experts in your field use the same practice? Is that common in your field?
Yes, I would think it would be common to use the media to gather information.
And the case that you cited to, then you actually went out and did independent research. Is that right?
That's correct. So in the case of which the detective forgot the gun in the bathroom, I went out on my own to confirm the circumstances that occurred in that article.
Okay, but just to, again, to clarify, because the experts in your field reasonably will rely on reviewing news reports or newspaper articles when they set up their opinions or when they form their opinions in their part of their research.
Yes, definitely. Experts would be using the media to help influence and help them to come to a final conclusion and opinions.
Now, let's go back to the interview, the Ross Harris interview. It was the second interview, but I think the confusion we had on Cross was it's listed as D1, but it's actually the second interview.
Okay.
So that was the time that you, now, if I remember right, did you go into the jail with a laptop?
Yes.
And the state took you down the list of a lot of things that, Your Honor, is there any way I can impose upon Brett real quick to put up D1?
Audrey's going to help us. There we are.
Okay, thank you. We can slide down just a little bit, please. A little further down to the, all right. When you're talking about, they got to the spots past issues for the second interview. Now, you had testified that some of those things, I think, were Ross Harris's words on direct. Do you recall that? Excuse me, on cross. Do you recall that? The words of Ross Harris, I think you were asked.
Yes, I recall.
Now, could some of those things have been Ross Harris's words, or could some of them been things that you had pre-typed in before you even met Ross Harris that day that you gained from your research and review of the evidence and your conversations with counsel, or both?
It's both. A good bit of it was what I had typed in advance, and some of it had included his answers.
All right, so not all of this is just what Ross told you, but there's other things as far as what your findings were and things that you had already listed down there as being important, as well as the counsel had talked to you about as being important.
That's correct.
And there's certain things on here that you slide down a little further, please. And there's certain things on this D1 bottom of this page that you're certain also, well, let me rephrase that. Are there things here that you know that the attorneys gave you and not Ross Harris?
I'm quite certain that I was given that specific time, 12:40, in which he had sent a work email that I would have gotten from the attorneys, and at 12:48 a.m. that he was applying for a passport.
And let's go to the second page, please. And on the second page, when you went in and you said, well, these are the words of Ross Harris, on several lists through these again, are any of those you're certain are just Ross Harris's words, or could they have been words of counsel and yourself that was already typed in?
My best recollection would be that this is what I got directly from Ross Harris at the top of this page.
The top of this page, okay. And would that have been typed in that day?
I would think so.
Okay. And then the part in bold is it says need to find out original meeting time. I believe you've already testified that is a specific note to yourself for something you needed to check out because it was important to your findings.
That's correct. Just to confirm that he did have an early meeting time that day.
And now, as we scroll down there and go past the traffic out of Chick-fil-A, and the questions about knowledge of how to erase and more forgotten, we've gone over that, but I want to make sure it's crystal clear, or at least with me anyway. Are these things that you got from Ross Harris, or were they typed in there before you ever met with him?
That was typed in before I met with him.
There's no answers or anything there. Those are just things that you thought were important or the attorneys thought were important.
That's just something I thought was important.
And with all those questions, the next three questions, starting with knowledge, more and more, those were what you thought were important, and you
That's correct.
Walk there. Okay. And as far as the first two I talked about, knowledge of how to erase internet history, you don't have an answer there, do you?
No, I don't.
And you don't have an answer to the second question you have there either, do you? About more about forgotten baby.
No, I don't.
Now the hypothetical, you put that in there all by yourself, did you not?
Yes, I did.
And you have here, you couldn't answer the question other than to talk techie. Now, that's added right after that question mark. Is that correct?
I'm sorry, what was your question?
All right. You typed in, couldn't answer the question other than to talk techie right after that, those list of questions there. Is that correct?
I'm sorry, again, I couldn't hear the last thing you said.
Very last portion of the question on the hypothetical, where it said, you typed in after the questions, and it is not his exact response. Is that, or is it his exact response?
No, that's not his exact response. That was just my impression of what he was saying.
Okay. And again, this is something you put down there and that you wanted to know, but it was also something you thought was going to be confidential.
That's correct.
That you were told about counsel.
Correct.
And the last page, again, are those things that were exactly things he told you, or were those things that came before you got there, or the type before you got there and he either confirmed or they're just questions?
Now, are you talking here traffic out of Chick-fil-A?
Oh, excuse me. I'm sorry. Let's go to page 3, please. I thought it was. Could we go to the next page, please? Now, when we're going down from the forward-facing seats and all that, would those be things that you typed in while you were talking to him, or would those be things that could be a combination of both his responses and things that you had came in there with pre-knowledge from the attorneys in your research?
That would have been something I typed in at the time.
And then the very last line, second to last line, midnight project, different. We've gone over this, but again, there's questions there that you have where things are written down, and in particular about things that you think are important and that you need to check out later on.
What are you referring to?
The very, the last line, when saved, there's a question mark. If you could slide down a little further, please. Good. The when saved and there's a question mark.
That's just a question for me to follow up on.
And again, that's not something Ross told you. That's part of what you're doing as an expert in this case. Information that you need to seek out and think is important.
That's correct.
Part of your work product.
Correct.
Thank you. I don't have anything else at this time, Judge.
Further examination by the state?
Thank you, Your Honor. Dr. Diamond, is it fair to say that if you had not interviewed Ross Harris, you would not have been able to render an opinion at trial? Is that correct?
That's correct.
And so therefore you had to have based your opinion about the consistency between prospective memory failure and his actions on his 2 interviews. Is that correct?
That's correct.
So it was very important that you interview him and hear what he had to say, and that formed the basis of your opinion that you were going to give at trial.
Correct.
I'll pass the witness, Your Honor.
I don't have anything else.
Can the witness be excused?
You may. Thank you for your time, sir.
From the
Thank
state,
you.
yes.
You're free to go, Dr. Diamond. Mr. Durham,
you.
do you have further evidence?
I do, Judge. But
Please
can
proceed.
go ahead and call Maddox Kilgore.
All right, is Mr. Kilgore available? There he is. What do we need to do? Does he need to come online? He's there. Yeah, there he is.
Sorry.
All right, Mr. Durham, Mr. Kilgore's on Zoom. If you'll
Could
switch
I have just 1 second, please?
examination.
Just give me 1 second. Let me get my
Sure.
files here.
The lady in the corner is covering his face.
Oh, where can I just start there? Any- You did. Where? Oh, here we go. Is this it? There's more than this here. Okay, raise your right hand, please. You swear affirm the testimony you're about to give this court and the matter pending before it shall be the truth.
The whole truth and nothing but the truth, so help you God.
I do.
Tell us your name, please.
Maddox Kilgore.
And what do you do for a living, Max? Mr. Kilgore?
I'm an attorney,
Where at?
Marietta, Georgia,
And how long have you been an attorney?
since 1994.
Where'd you go to school?
At Emory University and Samford University.
And what did you, have you been in private practice your entire career?
No,
And what did you do when you first got out of school?
so I was a law clerk for a few years. I was a law clerk in the Superior Court of Cobb County for a short time. Then I was a law assistant on the Georgia Supreme Court for Justice Harris Hines. And after about 2 years as a law clerk, I was an assistant attorney general in the state of Georgia. Worked for Thurbert Baker, and then and Mr. Bowers. Did that for about 5 years or so. I was in the criminal division, handled habeas corpus and appeals before the Georgia Supreme Court. Then I was a prosecutor in the Superior Court of Cobb County. Worked for Mr. Pat Head, who was the DA at the time. And I was there about 6 years or so, tried felony cases. And then I went into the private practice of law the January of 2006.
Okay. And in your time you've been in private practice, do you have a degree of concentration in the type of cases you do?
Criminal defense.
And do you do, what kind of cases do you represent people on?
Well, really any kind of, anything related to criminal defense, misdemeanors and felonies. Also have done a lot of post-conviction work. I've done lots of motions for new trial and direct appeals.
Well, did you, have you done murder cases?
I have.
And did you have occasion to represent Ross Harris, start representing him in this case that we're here for today?
I did.
When did you start representing Ross?
My recollection is that Ross's family came to see me the morning after he was arrested, which was June of 2014.
Okay, and did he, so that was immediately after he was arrested then, is that correct?
Yes.
Okay. Did anybody help you with this case?
Yes. Over the course of the next 2 years, my law partner, Carlos Rodriguez, worked on the case. Another attorney, Brian Lumpkin, a local attorney in Marietta, worked on the case. The two of them were co-counsel with me. We also had assistance from at least one private investigator. And there may have been, we may have had some additional help, but those were the primary, that's the primary assistance that I had.
Okay, and did you, when you're doing a case like this, and we'll just specifically this case, did y'all, after you got through and we began reviewing the evidence, did y'all ever get a theory of defense or the plans about how to handle the representation of Ross Harris?
Absolutely. I mean, early on, it was clear that we were going to have a legal defense of accident that was based on memory failure, and that was, I think that defense pretty early on was going to be based largely on the work of Dr. David Diamond. We expected for him to be the primary witness as far as the legal defense goes of memory failure of accident. as it turns out, we had to turn over his some work product confidential notes, and that pretty much scuttled our ability to call him as a witness. And so
we'll get to that in a second. But your theory of the case that you talked about, he was the centerpiece. What other pieces did you have for the accident portion?
Well, for the memory failure portion, we had another expert that we got later on, and that was Dr. Brewer from Arizona State. So he was going to be, and he did testify. He was going to be part of that accident defense. I mean, those, the experts were the big part of the memory failure defense, but the context of the trial, the other witnesses that were called, there was, of course, a lot of other evidence that undergirded or supported the memory failure defense. But I want to make, I'm sorry.
Go ahead.
So, but I think to more fully answer your question, very early on, we developed a strategy that we knew we were going to have to employ, and we did employ at trial, and that was really to undermine the motive theory of the state. And we were going to do that by challenging the credibility of the state's witnesses, primarily the law enforcement officers and the state's experts. The state had suggested a motive that Ross wanted to basically live child-free in order to pursue extramarital sexual liaisons. And we determined throughout the course of preparation that there was no objective evidence of such a motive. And as it turns out, what the state really had, we felt what they had and what they were putting up to sort of carry that motive was bad character evidence and some very misleading false testimony of the law enforcement officers and experts. And I know that, the defense doesn't have a burden of proof to prove anything. But in a case like this, there's a dead baby, and we certainly believed that it was incumbent upon us to prove that the law enforcement officers were not credible, that the state's experts were not credible, that they were lying to sort of fit their narrative, and I mean, there was, and we had a lot of ammunition in that regard, including a lot of false testimony that was given during the probable cause hearing, and we did get to challenge the detective on that false testimony. But we felt.
Let me just we'll go to that. I just want to break down right now the so you had basically, as I'm understanding it, it was a two-prong that you were focused on, and one would be the legal defense, and the other would be a very strong part of your case was attacking the state's motive. Is that summary?
Yes. Yes.
All right. Now, going back to the first prong, the legal portion, with you had Dr. Diamond and Dr. Brewer. How are you going to work those guys together?
Well, Dr. Diamond he was and is probably the most renowned expert on this paradigm which occurred in this case, and that is memory failure of a parent leaving a child in a car. And Dr. Diamond had, and he's an academic, but he's a forensic expert as well, and by that I mean sort of where the law intersects with this science. Diamond is the guy who has handled lots and lots of these cases. He's consulted with prosecutors, with defense attorneys, with other experts, defendants, and he has an expertise, a very hands-on expertise in these types of cases. In other words, he's the guy who's handled a lot of these firsthand. Dr. Brewer, on the other hand, he got involved in the case much later. He was he's a very sharp guy, but he is clearly an academic. Dr. Brewer at that time ran a memory study laboratory at Arizona State University. And what he had to bring to the table was essentially an academic perspective on memory failure. And but he had no practical experience. He had never handled any sort of case involving the death of a child where there had been a memory failure. He just didn't have that experience. So the intent and the plan was for Dr. Brewer to sort of come in as a strictly scientific academic guy, lay down the basics for what the construct of memory failure from a scientific perspective, and then have Dr. Diamond come in, who is also a scientist, but have Dr. Diamond come in and be able to really be the cleanup hitter, if you will, for him to make the connection between the science and the paradigm of these cases happening in the real world. You know, our hope was that he would be able to offer very strong opinion that what he observed in this case was consistent with memory failure. But more importantly than that, probably, is that we had hoped and expected David Diamond to be able to testify that what he observed in this case was consistent with memory failure he had seen in numerous other cases where children were forgotten in cars.
Okay, and did you y'all wind up employing Dr. Diamond?
Yes.
Now, do you remember meeting with him?
So we worked extensively with Dr. Diamond over a period of probably, well, certainly more than a year, maybe even a year and a half. We flew him up to Marietta, and he met with us in our office. I want to say at least twice. We provided him with numerous materials and videos and thumb drives and reports. In this case, we took him to the scenes. We took him to drive the scenes, to drive the route in question. We flew down to Tampa and met with him at the University of South Florida for, gosh, it seemed like half a day for him to try to help us understand the science of memory failure. So, I mean, he was all in, that's for certain. He was certainly willing to help us understand the science, and he was certainly willing to offer his opinion that this was a case of memory failure.
And so when you mentioned all the times that you spoke, well, not all the times, but that y'all met now, did you have other communications with him other than meeting him face to face, as far as phone calls, emails, things like that?
Of course.
And did you give him information?
I'm sorry, bitch, say again.
Did you provide him information?
He was provided a tremendous amount of data on this case, including recordings and videos, reports. I've been practicing, 26 years. I don't know that I've ever worked as closely hand in hand with an expert on strategy quite as much as we worked with Dr. Diamond, because, well, the reality is he knew so much more about this paradigm than we did. I mean, he'd handled a whole bunch of these cases, and we'd never handled a case like this.
And so when y'all met with him, tell me about the meeting here, the first time that y'all met with him. Tell us about that one.
So, to the best of my recollection, both times that Dr. Diamond came to Marietta, we made arrangements for him to go to the jail. I think the very first time we may have met Ross with him in the jail. It's been quite a few years ago, but that's my recollection, that we may have gone to the jail with him to meet with Ross, to kind of a meet and greet, I guess, if you will. But most of the time with Dr. Diamond, definitely on that first trip, was spent in our office going through the things about the case that we knew and the things about the case that we were concerned about.
There.
I'm sorry?
Who was there at that meeting?
At that first meeting, my recollection is that it was myself and my law partner, Carlos Rodriguez, and I believe that the investigator was present during that first meeting.
And what was y'all were telling Dr. Diamond information and providing him information about the case?
Yes.
Did y'all show him at that time? Did y'all show him any videos or any of the evidence at that time?
So, because we met on more than one occasion, I don't have a crystal clear recollection of when we showed him what evidence. We absolutely showed him video recordings in our office, as well as provided him with some sort of digital medium. There was, at some point, we definitely sent him a thumb drive with some recordings on it, but in our office, we absolutely went over the evidence with him. What we went over on the first occasion versus the second occasion, I just don't have a crystal clear recollection.
All right. Well, what was Dr. Diamond doing while you guys were providing him with this information, or while he was reviewing information?
You talking about at our office?
Uh-huh.
Well, he had his laptop out, so he was working on his laptop, and he was asking a lot of questions.
And what were y'all providing him?
Well, I would say it was a combination of facts, objective facts that we knew from the case. We were providing him information that Ross had given us. In other words, from our conversations with Ross, we were providing him with our opinions about the evidence, and we were providing him with opinions about our strategy going forward.
So y'all were telling him things that y'all were working on the case, and as far as how you wanted things that you wanted to highlight or try that you thought were concerns?
Yes.
And what was he doing when you're telling him that information?
Well, he had his laptop out. He was typing and asking questions.
Okay. All right. And so did you go with him and have an occasion to go with him and the people to meet with Dr. Diamond to meet Ross Harris?
Yes.
And tell about that, please.
So
first
to the
time,
best,
one at a time.
I'm sorry, say again.
Let's do it one at a time. What happened on the first meeting when y'all went there?
So to the best of my recollection, the first time Dr. Diamond was in Marietta, we went to the jail with him and we met with Ross. And my recollection is it was kind of a meet and greet. I just don't recall, I just do not recall whether or not we left and Diamond met with him privately that first time. I just don't recall. I just don't.
Okay, but all right. Do you know, did y'all talk a lot about the case then? Or what kind of meeting was it? You said, did you say meet and greet? Did I hear that right?
So the very first time that we were present with Ross and Dr. Diamond in the jail, that's the only way that I can characterize it. We definitely had a conversation about the case. At this time, I do not recall if it was more biographical or case specific. And when I say meet and greet, I don't mean 5 minutes. I mean, my recollection is that we talked to him for a while. I did not take notes of that meeting, so I can't at this time recall specifically the topics that were covered. I'm pretty confident it included a lot of biographical information, a lot of background information about Ross, because obviously this is the first time that Diamond was meeting him. And I believe, in fact, I'm certain that Diamond asked him a couple of questions, but at this time, I don't recall what they were.
Do you recall talking with Dr. Diamond about whether or not anything any of his notes were confidential?
So that topic absolutely came up during the course of our relationship.
Okay. Do you remember what you told him?
My recollection is that the topic was discussed several times, both before and after the state asked for his notes. And my recollection was that we would have told him, or we did tell him, like any other expert, that his notes, any work product were confidential.
And okay, so now do you recall preparing your opening argument for the case?
So I've had a chance to glance over that, so I have refreshed my memory somewhat to the opening argument.
Did you make reference to Dr. Diamond in the opening?
I don't recall.
Okay.
I do recall that we talked about the fact there was going to be expert testimony that went directly to memory failure. I'm certain that I mentioned the fact there would be expert testimony.
Okay, and did you your purpose for Dr. Diamond was you'd mentioned before, and I want to make sure we get it here and don't get confused. What was specifically the difference between using him as opposed to Dr. Brewer?
So again, Dr. Diamond had handled a lot of these kinds of cases and could give very specific opinion. He could give specific opinion testimony that what he observed in this case was consistent with other like cases of memory failure where parents had left their children in cars. I think that's, I mean, if you're looking for one thing that really sums up that's what the difference was. I mean, he could offer that opinion, and Dr. Brewer could not. And let me let me interject this. Dr. Brewer had, because he had never worked on anything like this before, he was extremely reticent to give firm opinions. And he was extremely reticent to give an opinion that in this particular case, it was the result of a memory failure. You know, we didn't think that his inability to give that opinion was really, quite frankly, was detrimental, because the science that he was going to be talking about was the science, and it's the same thing that, you know, Dr. Diamond was going to talk about. But I think one thing really sort of, you know, makes the point here in when Dr. Brewer testified, the very first question that the state asked him was, "You are not here to give this jury an opinion that this incident here was a failure of memory systems." And his response was, "No, that's not my role." Had that same question been asked to Dr. Diamond, his response would have been, "Absolutely, that's my opinion. It was absolutely this case is a result of a failure of memory, just like so many of the other cases that I've looked at." So I think that's I think that was a big difference in the two of them. I mean, there were a lot of little things. Dr. Brewer was able to discuss the concept of false memory, but he could only do it in a very general way. You know, in other words, he could say, well, you know, there's information out there that parents, in these cases, parents tend to report that they have a specific memory of dropping their child off at daycare. Dr. Diamond, on the other hand, on that topic, you know, would have been able to come in and speak with great authority that he had been involved in, you know, dozens of cases specifically involving false memory. So that's just, I mean, that's just an example of, you know, some of the things that I see were very different. I did in looking through the transcript, I noticed that Dr. Brewer was crossed a little bit about whether or not there were, he was familiar with a case involving a memory failure over such a short drive. And of course, he, you know, Dr. Brewer testified, well, I've never worked on any of these cases. Well, you know, that was an important issue in this case because the drive that Ross made from Chick-fil-A to Home Depot was very, very short. Well, Dr. Diamond, because he's handled so many of these cases, I mean, he would have been able to say, absolutely. In fact, you can, there are instances where the time for the memory failure was shorter. The drive was actually shorter than this one. And I have very distinct memory of Dr. Diamond telling us that. So, I mean, those are just some examples of how I think that Diamond would have been a different witness, given a different kind of testimony.
Did you recall these? Before we get into the motion to compel, let's go into some other things. When you looked at this case, did you file what motions? Did you file a motion to sever?
So I apologize. What are you asking me?
Well, I'm going to ask about a few of the motions. We're going to go into some more later on, but just a few of the motions. Not as much detail right now, but did you happen to file a motion to sever in this case?
Yes.
And previously you had mentioned the bad character evidence that you were concerned about coming in. Is that one of the reasons you filed a motion to sever?
Yes.
Okay. And you filed motions in limine in this case as well. Some of those doing with that bad character.
Yes.
Okay. Now, you've also recalled the state filing motions in the case as well.
Yes.
And in particular, one is a motion to compel.
Oh, yeah.
Okay. Tell me about the motion to compel. Let's talk about that one right now.
Well, the state was asking for the court to make us turn over the notes for Dr. Diamond.
And what notes were they asking for?
I apologize. I don't have that motion right in front of me.
All right. Do you happen to have the order in front of you?
Hold on one moment. Let me see if I can locate it. There may have been multiple iterations of their motion, but so the state wanted to disclose documentation regarding a statement the defendant gave him.
And when was it filed?
So I think the state's motion was frankly quite broad in what they were asking for. In refreshing my recollection, I mean, it appears they're really asking for any notes of Dr. Diamond that even touched on conversations with Ross Harris. So I've got one that shows that it was submitted April the 9th.
Okay.
I think we actually got the motion prior to that. I think they emailed it to us or gave it to us a couple of days before, though.
All right. And did that motion, did y'all have a hearing on the motion?
Yes.
Did you consent to them getting materials?
Absolutely not.
Okay. What was your concern about the materials?
Well, got quite a few concerns that I had. First and foremost, this was Dr. Diamond had told me very clearly that he did not have a recordation of any specific responses that that Ross had given him. Dr. Diamond made very clear what he had was essentially a go-by, which were some notes that he had taken into the jail to allow him to talk to Ross. In other words, to refresh his recollection of what he needed to talk to Ross about. So those notes and that go-by that he had, they were based on conversations that he had with the lawyers, that he had with us. And my understanding is that he then took those notes into the jail. And I don't know if he took them on paper or on a computer, but my understanding is he took them into the jail and then at some point may have amended or supplemented those notes with either his own impressions or maybe even a specific response that Ross had given him. But they were everything was combined in just a couple of pieces of paper. And so, yeah, I was, we were extraordinarily concerned that this, confidential work product, which was notes between the lawyer and the expert, were going to have to be turned over. And we were concerned for lots of reasons. I very specifically warned Dr. Diamond that this was going to create a real problem with credibility if they had his notes that the state could then come in and demand that he give an answer for every issue, every statement that was on that piece of paper, answer the question the way that Ross Harris had answered it. And of course, that would have put Dr. Diamond in an incredibly difficult position. First of all, this was months and months and months and months before trial to try to recall that information. So that was, I definitely knew that was going to be a problem with his credibility or a challenge to his credibility. But more problematic than that, there were certain statements in this work product in these notes that the state was asking for that we were concerned that the state could then take those statements and turn them around and give whatever meaning the state wanted them to mean. And let me just give you an example. I've got the notes in front of me. So on page 2, he's got in his notes knowledge of how to erase internet search history, more about forgotten baby dog search history. Well, these were extremely contested issues. There was no objective.
We're going to get there. Just say, I don't want you to get too far ahead of me. When you had the hearing, now did you you expressed the concerns you had to the court?
I have very little recollection, very little recollection of the first hearing. I'm going to be honest with you. I didn't dream in a million years there was any possibility that the court was going to make us turn over these notes. And if I dropped the ball in the first hearing, I dropped the ball, but I just don't have any recollection of what we argued that in court that day. Okay.
Do you recall, you mentioned that was the first hearing. Do you recall a subsequent hearing?
Absolutely.
Do you recall that one better?
Very much so.
Why?
Well, because we made our point very strongly to the court that these were work product that should not have to be turned over, and there was no law in Georgia, there was no statute, there was nothing that would have covered these particular notes to be required to be turned over. And of course, by that time, I had, after we mulled over what was actually on these notes, we were extremely concerned about the state getting these. And my recollection is I basically begged the court not to make us turn over these notes. That is my recollection of sort of at least what our mindset was at the time, and what my mindset was at the time, because I knew what kind of problem that it was going to cause us and going to cause our expert.
Yeah, you said
and let me just follow up on that. My recollection is that even the prosecutor said something to the court about, well, maybe we need to sort of let them redact any of the work product stuff so that it's not a problem. And the court said, nope, as is. They got to turn it all over.
Okay. And did you explain legal arguments to the court? Well, I mean, that you were begging the court, but did you explain your legal arguments as well in the court hearing?
Yes, I did.
And also, you filed a written motion in opposed to that, did you not?
Yes, I did.
Actually, let me rephrase it. It was a motion of reconsideration of her direction about giving over the materials.
Yes.
Okay. And now, were y'all required to give all of the statements that were taken, all the writings and statements regarding any conversation in any manner?
That's my recollection.
And so let's go over that. You said you had those interview notes with you.
Yes.
And Judge, if we could, I'd like to see if the court could help me out again with D1.
I think we're getting it done.
Thank you.
There.
Okay, Mr. Kilgore, let's go over this. Do you have any recollection as far as talking to Dr. Diamond about the first line underneath the second level where it says habit and pattern?
So that was something that we talked about extensively with Dr. Diamond.
And that was, when you say we talked about it, is that you and the trial team?
Yes.
Okay, and did y'all tell him what you wanted him to find out about that, how you thought it may relate to the case?
We told him what we knew about. We told him what we knew about it, and because he had done so many of these cases, I mean, he really knew what to follow up on. But we told him what we knew about the habit and the pattern in this particular case, or at least what we knew at that point in time.
Okay. Now you mentioned that what you knew in that point in time. Was this case unusual and complex in how information came in at different times?
Yes.
Tell us about that.
Well, the volume of information was unlike anything that any of the lawyers had ever been involved in. We're talking terabytes because there was so much digital information. Dozens and dozens and dozens of witnesses, many experts in different disciplines, but it was really the data and of course recordings. I mean, I can't even tell you how many recordings there were. There was a Pharaoh scan done and recreation, essentially an animated recreation done.
All right. Well, let me do. But as far as when I'm talking about the electronic, was there certain things that were in question early on that you may have had question about that got cleared up later as more digital information became available?
Absolutely.
Okay.
Absolutely.
We'll talk about that in relation to this first page here.
So,
can we slide it down? Can it be scrolled? Okay, right there. Did I go too far, Maddox? But is there something on this page that deals with that?
So, do you mind restating the question, please?
Okay, well, I'll tell you what, we'll get to some. I know it's on the second page, but these things right here at the bottom of D1, the thing about the time frames, do you recall talking to Dr. Diamond about those?
Oh, absolutely. Absolutely. We at some point in time we had some information about some digital information, either from cell phone download. I think we had a cell phone download pretty early on. And then we had additional information where laptops were downloaded. And at some point in time, we knew that there was an email that came in to Ross from his work in the middle of the night before. And we knew that Ross had been searching for passport fees for Cooper because he was planning a cruise. He was planning on taking his family on a cruise, including Cooper. And we discovered that he had been looking for passport fees in the middle of the night. I think this may have been some information that we might have gotten a little bit earlier on.
Okay. Let me, if we can, please, clerk, slide up just a little bit closer to the top again, where it says issues for the second interview. Right there, please. Thanks. All right. Now, underneath issues for the second interview, you see kind of a list of things. Did y'all talk to Dr. Diamond about these things that are coming down there from more discussions about the relationship with Cooper, things like that, that scroll all the way down to the time frames you were just referring to? Do you recall having specific conversations with Dr. Diamond about these things?
Yes, I'm confident that these were the things that we discussed with him in our office that we found significant and wanted him to follow up on.
Okay. All right, let's go ahead and go to the second page, please. All right, thank you. Now, anything at this top of this page that this stands out to you about conversations that you had with Dr. Diamond, that information would have been provided by y'all that you thought was important?
So I think that it's all important.
Okay.
This is all stuff that we talked to Dr. Diamond about. Every bit of it, every bit of this is stuff that we talked to him about. So the last item there, received a message en route of a change in meeting time. May have changed his route, but may not totally sure of plan. So this was an issue we believed was of great importance, that dealt with, there was some digital evidence that indicated that Ross had some kind of meeting that morning, and sometime during the morning he was notified of a change in time for his meeting, which we believed at that time was the basis of why he amended his morning and changed his schedule, and made a decision last minute to take Cooper to breakfast. But the exact timing of when that email was received and read, in conjunction with some other evidence, that was something that we were not yet entirely clear on. And I think that's why it says may have changed his route, but may not totally sure of a plan. I will tell you that in preparation for trial, we spent a lot of time on that very issue right there. And as a matter of fact, we mapped out routes. We mapped out all kind of routes, and we laid out over it the different times of the digital evidence, trying to sort of reconstruct when he had received this message and how it impacted his morning. But I believe at the time we talked to Dr. Diamond about it, I don't think we yet fully understood the evidence and how we could use it.
Okay. And did that clear up later on after you received more digital information?
It certainly cleared up enough for us to be confident in how to use the evidence. Yes.
Okay. All right. But at the initial time you met with Dr. Diamond, you hadn't had that information yet.
Well, we had some information. but we had sufficient information to know that there was something about an email and a change in time, a change in a scheduled meeting that was going to have some effect, very likely had some effect on Ross changing his plans that very morning. But understand this, it's not enough. It's not enough for Ross to tell us that or for us to believe it, because we had to be able to pin it down with the digital evidence. Because if we asserted something that he had changed his morning routine as a result of an email, and then it turns out we were wrong about it, well, then, we're going to lose credibility with the jury. That was an evolving issue as we prepared for trial and continued to review evidence. And
right below that, it in bold, it says need to find out original meeting time. Is that something you guys talked about as well?
Absolutely. Please understand that part of what Dr. Diamond taught us about about memory failures has to do with habit and a change in pattern. And so if we could establish that, there was some change in the morning that would have altered his routine in any way, well, that was going to have some bearing on whether or not this might be a good case for memory failure. And
going down to the next line, there's something about some information about the Chick-fil-A manager. Now, when did y'all, is that something Ross would have known, to your knowledge?
Absolutely not.
Why not?
He didn't remember that.
Okay.
He didn't have any recollection of it. That was something at some point in time. Remember, there is an enormous amount of information in this case, and so it took numerous conversations with Ross just to tell him what we knew about the evidence. But my recollection is that Ross had no knowledge of anything about the manager at Chick-fil-A. That's something that we believed was important after talking to Dr. Diamond, because it may have had an impact on whether or not Ross was tired that morning, whether he was exhausted, or whether he was in a hurry. And Dr. Diamond explained to us that those kinds of things, were part of his analysis of whether or not there was a memory failure. And so that's why we discussed that with him.
Now, did you do a drive around with Dr. Diamond as far as the Chick-fil-A area and the Home Depot area? Am I the only one that doesn't hear anything?
He appears to be frozen.
Yeah, okay, thank you. I was beginning to think it was me.
What's wrong?
Your Honor, I believe that Mr. Kilgore's feed has stopped and he is now frozen, so we are unable to communicate with him.
He'll figure it out. There he is.
Can you hear me, Mitch?
I can't now, but
So
that was a great answer that you can repeat, because we didn't hear anything else.
So as far as the drive goes, the answer to the question is yes. Are you still there?
I am. We put this back to the mirrored screen, but we need D1, please.
All right. Well, while you're fooling with that, I will tell you, yes, we drove the routes with Dr. Diamond, but in addition to that, we provided Dr. Diamond with the recording where Detective Stoddard had taken the drive or timed the drive on several runs.
All right. Now, sliding down a little bit about the knowledge about how to erase an internet history in question mark. You mentioned earlier about that and it stopped you. Did this cause you any concern?
Yes, that probably gave us more concern than anything else in the notes.
Why?
Well, because the objective evidence was that there was no evidence that Ross had erased his search history, because the state wanted to suggest that he had been searching for things, nefarious things, and had been able to delete or erase those matters from his search history. Of course, this was a tremendous part of the defense, because we were arguing that there was absolutely no search history whatsoever for anything like, children left in cars, how hot does a car have to be, divorce lawyers. There was nothing like that. There was no search which supported the state's suggestion of motive. Objectively, there just wasn't anything there. However, the state continued to suggest throughout the trial that it didn't make any difference because Ross was able to get rid of that stuff. They continued to suggest that he hid it or he erased it somehow. He had the ability to do that. So just because it's not there doesn't mean he didn't do it. Well, this line in here, knowledge of how to erase internet search history, at the very least, it demonstrates that the defense team and the defense expert is concerned about it, is worried about it, is looking into it, is asking about it. And that's absolutely contrary to what our defense was. Our defense was that it ain't there, period. He didn't do any searches like that. It's not there. But now, now after we had to turn this over, the state had a document that demonstrated the attorneys and the expert were worried about that, concerned about it, and had questions about it. Yeah, it was a real dagger. It was a real problem for us.
Well, did you have concerns about the next line about forgotten baby dog search history?
Same thing. Same thing. There was no objective evidence whatsoever that there was any search regarding a forgotten baby, nor anything involving searching for a forgotten dog. The only evidence was that on Ross's Reddit page, a public service announcement had popped up on his Reddit page, which he had apparently played or at least accessed, but there was no evidence of a search history for anything like that. So again, we had to turn over a document that says, it's pretty clear this is something that the attorneys and the expert were concerned about. They've got questions that we're going to ask Ross about information about his search history on these topics, forgotten baby or forgotten dog.
Well, let me ask you this, because let me go back up to knowledge of how to erase internet search history. There's a question after that.
I apologize. I couldn't hear you.
Oh, okay. Let me get closer. Going back up to the knowledge of how to erase internet search history. There's a question mark after that. Correct?
Yes.
Okay. Would that indicate to you whether or not it might be something that, looking at it from somebody else's perspective, Could it be argued by an attorney that's a question that y'all were going to ask, somebody's going to ask Ross Harris?
It could be taken a number of ways. I'll tell you the way we took it was that it's on paper, and the state could make it mean whatever they wanted it to mean.
Okay. Well, down here, more about forgotten baby dog search history, there's no question mark.
Right.
Do you think that could be a statement that somebody could read that as a statement about Ross gave them or gave Dr. Diamond more information about the baby and the dog search history?
Absolutely.
And is that one of the concerns you were talking about?
Yes.
All right, if we can go forward, a light bulb purchase, and is this something that y'all went over with him? When I say him, I mean Dr. Diamond.
Absolutely.
Now, was there video of that as well?
Yes.
Did y'all show that to Dr. Diamond?
Yes.
Okay, and is that something that in y'all's conversation was very important?
It was important during our conversations with Dr. Diamond.
Okay. Now, go ahead.
It's hard to imagine there was a more hotly contested issue at trial than that, about him putting light bulbs in the car. But yes, we discussed it at great length with Dr. Diamond. We showed him the video, and I mean, he was very, very engaged. I mean, he asked us questions, and I'm quite certain that he discussed this with Ross.
And this hypothetical, was that a concern for y'all?
Absolutely.
Explain to me why that was a concern, that the state would have this document with that hypothetical question.
So the hypothetical, what if you wanted to leave Cooper in the car intentionally and made it appear it was a memory error? How might you use the internet to carry out the plan and cover your tracks? Well, I mean, that's pretty much that's pretty much the state's theory. That was their theory. And here we're turning over a document that has got that very theory in black and white on a piece of paper that now says, well, the lawyers and the expert apparently concerned about this as well.
Does it have a follow-up after the questions?
What?
Does it have a follow-up after the questions?
That he couldn't answer the question other than talk techie. And so I now know that was an answer that Ross gave David Diamond. I now know that, which again to me is very clear evidence that these confidential work product notes were created over a period of time, not just one sitting. But yes, it was an extreme concern to us, because I could just imagine in closing argument, you know, the state asking these questions. You know, what if you wanted to leave Cooper in the car intentionally and make it appear it was a memory error? How would you cover your tracks? You know, Ross Harris couldn't answer that question, but I think it's been answered during this trial. I think that question's been answered during this trial. You know, seems to me if somebody was innocent and that question was posed to them, what they would say is, my God, why are you asking that question? Are you kidding me? That's outrageous. How dare you? I can't even imagine. I can't even conceive of such a thing. And because it's now on a piece of paper that the state has, they can use it as a weapon when they cross-examine David Diamond and confront him with that, as well as in closing if they wanted to.
Okay, going on down. Now down here you have a lot of things about Chick-fil-A. Does this tie in with a little bit of what you were talking about earlier about things that you learned and you were having to explore and learn over time?
Yes.
Tell me how it ties into that.
So I think as it relates to Chick-fil-A, we had a lot of information early on, but what we did not know early on, and we could not pinpoint early on, was precisely how many times a week Ross would go into the restaurant versus going through the drive-through, and precisely how many of those times over a period of a week or a month that he would take Cooper to Chick-fil-A. Would he do it through the drive-through, or would he go into the restaurant? And the reason why that was important was because it went to his habit and his change of pattern that morning. Ross was not a very good historian he did not have a good recollection of how many times he went to Chick-fil-A and went through the drive-through or went in or took Cooper. He's very prone to exaggeration, so much so that we just could not, we couldn't rely on what he was telling us because it was exaggerated. And so it was very painstaking over a period of a year to get information such as credit card receipts, credit card bills, all the information that we could gather in order to figure out how often did he go to Chick-fil-A? How often did he go through the drive-through? How often did he go in? And how often did he take Cooper? Although we never had absolute specifics, we certainly narrowed it down much better than we did early on when these notes were discussed with Dr. Diamond.
And again, these are things that y'all were concerned about as part of your strategy and how to address the issues at trial.
Yeah, obviously it definitely played into strategy.
All right. Let's go, if we can, scroll to the next page, please. Thank you very much. The thing up here about didn't text till while driving, is that something y'all discussed?
Yes.
And was that something that was an issue with you guys?
Very much so.
How so?
So the state wanted to suggest that Ross was texting during the drive from the Chick-fil-A to the treehouse. That was something that wanted to suggest. And the reason why was because if Ross was texting during the drive over, that would be illegal and it would be reckless and careless. And so that would diminish any defense of memory failure. Because if his memory failure was based on something he was doing that was illegal or reckless or that he shouldn't have been doing, such as texting while he was driving with a baby in the car, then it totally would destroy the memory failure defense. What we knew early on is that Ross told us he didn't text while driving. That's what he told us. But at the time that we talked to Dr. Diamond about this, we just did not have, we had not gone through all of the evidence sufficient enough to tie the timing up to be able to conclusively determine that he was not texting while driving. Now, ultimately, we were pretty confident that the digital evidence and the videos from the Home Depot treehouse and the Chick-fil-A, when you kind of put them all together, ultimately we were able to demonstrate, I think pretty conclusively, that, he was texting before he left Chick-fil-A, and he was texting when he got to Home Depot Treehouse, but he was not texting while he was driving. But at the time that we met with Dr. Diamond and this document was created, all we knew is that Ross told us he didn't text while driving. And so that was something that was definitely needed to be followed up on. And we did follow up and provided additional information to the expert.
Okay. Just talk about car seats with Dr. Diamond.
Yes.
And how did that play into your trial strategy and your preparation for trial?
Well, the information regarding the timing of what car seat was in which car, when, and when they were changed out, a lot of that information came from conversations with Ross. Ultimately, we were able to confirm a lot of stuff with Leanna Harris, and actually with some other evidence in the case. We told Dr. Diamond what we knew at that juncture. Of course, the car seat was very important to the issue of Diamond had concluded or opined that there was a memory failure and a child was left in a car. My recollection is that they all were rear-facing car seats.
Okay. All right, and I won't call it the last section, the second last section where it starts public service announcement. That information, do you know if that came from you or your trial team?
So I'm confident we discussed that. I'm confident that we discussed that very matter with David Diamond. As you can imagine, he's not just going to take any case. He has to rule out that it was intentional. And I know that there was this nefarious suggestion about that public service announcement about that vet video. And so that was something that he asked us a lot of questions about, and that was discussed at quite a length with Dr. Diamond. I will tell you, I do not believe that the phrase public service announcement came from anybody but me. That is not the way Ross talks. I don't ever recall him using that particular verbiage. If I'm wrong, this was a couple of years ago, but when I reviewed this material, that's really the first thing that jumped out at me is that those are my words. That's my recollection.
Okay. And these last couple of things down there before you get to the spaces, did those come? Did y'all talk about these things about the stretch of the new project and then also the midnight project timestamp?
Yes.
All right. Why were those concerns?
Well, those were in response to what Dr. Diamond was asking us if there was evidence that Ross was exhausted or under stress. These were particular things that we picked out and advised him that could be significant evidence of either stress or exhaustion. Those very clearly were matters that were important to the defense. I don't think they were important at all to the state, but they were important to us. And of course, we were looking for witnesses and evidence to establish those facts.
Mr. Durham?
Yes, ma'am.
How many more questions do you think you have? How much time?
It's going to be a little bit longer. As far as this specific exhibit, I've got maybe one more question, but we have a whole nother issue as far as trial strategy about the statement. So
Why don't you finish up on this exhibit, then we'll take a comfort break for the afternoon.
thank you very much.
Yes, sir.
Okay, Maddox, from the video parked in the shade, is that something that y'all were concerned with or talked about?
That was very much an issue that was part of the defense. Very much an issue that was part of the defense. So much so that I believe very early on, we let Dr. Diamond know that we had a video of precisely where in the parking lot that Ross had parked. Because again, the state was suggesting that Ross had intentionally left his child in the car to die in a hot car, when in fact we had evidence early on that the parking lot was a very large parking lot, and he could have very easily put that car in very more isolated places in the parking lot where nobody would have walked by the car. Not only that, there were very, very few trees in the middle of that parking lot. And we noticed that where he parked was not only in the middle of the lot, but it was under the shade of a tree, which of course is contrary to the suggestion that somehow he was intentionally parking in a way to bake his child in the car. So early on, we went over that with Dr. Diamond so that he would understand what that evidence was and how it was inconsistent with this the state's suggestion of malice or intent.
Okay, thank you, Judge. That's all for this particular exhibit.
All right, let's break for till 10 after 3.
Thank you.
After you repeat at least 4, I didn't think more like 5.